Okay, Jakshay, you can start now.
Okay, thank you, Ika. Good evening, everyone. Thank you so much for joining me today in today's presentation. Um, so, in our series of contract law presentations, today I'll be talking about void and voidable contracts. Now, of course, we are very well aware that contracts are a daily thing in our lives. And I think it's very important to know that at the outset itself, before you enter into a contract, what are the consequences and obligations that you have in the contract to ensure that the contract is seen through and does not become rescinded or um, void at the end of or in the performance of the contract. So void or voidable. Let's look at the difference. Sorry, before I begin, can I just remind everyone housekeeping rules to just mute your microphone and switch off your video. If you have any questions, I can address them at the end of my presentation. Thank you. So for void contracts, we have, I'll take you through what are the issues pertaining to void contracts. So I'll start with public policy. I'll speak also about contracts that restrain trade, where mistakes are made by both parties or either one of the parties, and contracts that restrain legal proceedings. And then in terms of voidable contracts, there is coercion, there is undue influence, fraud, and also misrepresentation. Now, what are void contracts? So if you look at the Contracts Act 1950, Section 2, it defines a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So it's very important to know when your contract will actually become void. When it's not enforceable at all by law, that is when the contract cannot be performed, and that is when it will become a void. So there are contracts that are void ab initio, the Latin term for from the beginning itself. So where at the commencement of the contract itself, it's deemed the contract to be non-enforceable. That is where the contract will be void. So an example of this would be where there's the lack of offer and acceptance. So the very essence of a contract is there must be an offer and there must be an acceptance. So if the law does not see that there's an offer and acceptance, that's one way where the contract will be void. Now let's go into public policy. So an agreement to be voided on public policy has to be proven to be more akin to it being immoral rather than illegal. So if you look at Section 24, it talks about the consideration or object of an agreement being lawful, unless these 5 things. So unless it is forbidden by law, or is such a nature that if permitted, it would defeat any law, it's fraudulent, it involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. So where it is unlawful, that is where the contract will be void. And let me bring you to the next slide. Now, public policy is not defined in the Contracts Act. You can find it in common law through cases. So one of the leading Indian authorities on this is Central Inland Water Transport, where public policy is something that connotes some matter which concerns public good and public interest. So it has to be involving the interests of public. So public policy in contract law, however, it differs. It has more of a restrictive approach. And this is seen in the case of Teresa Chong against Kin, Kun, and Co. This is a federal court decision. Here, what was held was where a contract does not fit into one or other of these pigeonholes, but lies outside this charmed circle, the court should use extreme reserve in holding such contract to be void as against public policy and should only do so when the contract is incontestably and on any view inimical to the public interest. So what does this mean? It's not on every case that that a contract is void where it is immoral. So you have to look, it goes on a case-by-case basis, and there are few circumstances where it will be in breach or it's not in the interest of public. That's where the contract will be void due to the public policy limit. So looking at another federal court decision, in the case of Yoganandi Anaperempuan A.S. Tambai, is a federal court decision. What it held was, it did not be established that the contract was illegal. It was sufficient that its consideration or object had been regarded by the court hearing the case as being opposed to public policy, or which it regarded as being immoral. So the court went on to say that what would amount to something against public policy would vary from place to place. But one universal element in an agreement that would weigh considerably against public policy is one that concerns the matter of honesty or lack of it. So one very important matter that the court will take into account in determining whether a contract should be void due to public policy is where where honesty comes into play. So where there's on the surface itself, from the get-go, there is a lack of honesty, the court will not have it, and the contract will be void and non-performable. So going on to the second part, restraint of trade. Now, this happens where a party agrees not to trade or conduct his profession or business in a particular area for a specified period. So this is quite common in contracts, in employment contracts especially. Many employees, after working in a company for a certain amount of time, would then intend to move on and open up their own business or profession, which is will open up their own business in the same profession. So you can see that some companies would impose onto these employees a restraint of trade, where they are not allowed to continue the same business, that particular area, for a couple of years, let's say 2 or 5 years. So I've given an example here. So for instance, a rock band had a clause in their contract with their producer that stated that they could not record anywhere else for a period of 2 years after the expiry of their contract. So based on my explanation earlier, would this be considered as a restraint of trade? Yes. And if so, would it be a void contract? Now, this is actually a case that is very similar. Polygram records against the search. So here, the court held that once the Malaysian courts take the view that a particular covenant is a covenant in restraint of trade, the courts have no discretion but to declare it to be void under Section 28 of the Contracts Act, subject to 3 exceptions provided in the said section. So Section 28 is only applicable in cases where a person is restrained from carrying on his trade or profession in the traditional sense of the doctrine, that is, in the post-contract period and not during currency of the contract. So you are not allowed to trade in the same profession or business as post your contract once you've left the company. So this is what happened in the case of Polygram records. So we have seen public policy and restraint of trade. Now moving on to mistake. This is provided for in sections 21, 22, and 23 of the Contracts Act. And but the Contracts Act does not deal with the types of mistakes that you see in cases these days. It merely mentions what a mistake is. It really defines mistake. But at common law, the courts have taken a wider approach, and they have categorized it into these 3 categories. So you have common mistake, mutual mistake, which is pretty similar to a common mistake, and then you have unilateral mistake. So the first one, common mistake, happens where both parties make a mistake as to a fact that is fundamental to the agreement. So both parties agree and they accept that both are liable for the mistake that was made in the agreement. Mutual mistake is where the parties misunderstand each other. So it has to be proven that the parties actually intended something else than what was actually carried out. And finally, you have the unilateral mistake, where only one of the parties has made a mistake. So let's look at how these how mistake can actually make a contract void. So for a common mistake in section 21, where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void, as we are very well aware. In the case of Sun Li Huan, here it was regarding the defendant, Stablewin, not having the milling license. And here the court held that it will not render a contract void on the grounds of common mistake unless the common mistake involves a matter which is so fundamental to the contract that both parties regard it as a condition precedent to the existence of the binding contract. So it has to be a condition precedent. There has to be a condition preceding the entering of the contract, and the parties have to prove that the mistake was a common one from both sides. So the court went on to define fundamental, and a common mistake must either relate to the existence of the subject matter or involve the sale of property to a person who already owns it. So I will not deal with too many cases along this line. You can have a look, but this is generally how the courts have approached where a mistake is made, a common mistake is made by both parties. Now we have seen how void contracts, how void agreements, how contracts and agreements can become void. Now, what is the effect of a void agreement? This is provided for in section 66 of the Contracts Act. So what it states is that when an agreement is discovered to be void, or when a contract becomes void, any person who has received any advantage under the agreement or contract is bound to restore it or to make compensation for it to the person from whom he received. So now, where the court has held that, okay, the agreement is void, and what do we do now? So if the contract has been void, the party that has received a benefit, has received an advantage, is bound to restore it. So they have to return, for instance, if it's monetary, it has to be returned, or if it's non-monetary and it's not able to be restored or returned to the party who is detriment in the agreement, they'll have to compensate the aggrieved party. So this is how the courts will deal with it, and this is what happens when an agreement or a contract becomes void. So in West Star Construction, what was held was that it is manifest that this was also provided for in an Indian authority. It is manifest that in order to invoke this action, the validity of the contract or agreement should be discovered subsequent to the making of it. It only applies to a case where one of the parties enters into an agreement under the belief that it was a legal agreement, that is without knowledge that the agreement is forbidden by law or opposed to public policy and as such illegal. So it is very important for parties to know and to set out into an agreement or a contract, knowing the consequences that they may face if they have breached the contract in any way, or they cannot perform the contract as per how they intended to do so. So we have taken a look at how contracts are void, and when contracts are void, they are not enforceable at all. However, how about contracts that are voidable? Voidable contracts, as it sounds, is only voidable on the option of the parties. And how does this differ from void contracts? Let's look at the definition. Firstly, section 2I. An agreement which is enforceable by law at the option of one or more of the parties, but not at the option of the other, is a voidable contract. So let me explain. Essentially, when two parties enter into a contract, here what we mean by other is so there's the one party and then there's the other party. So when two parties enter into a contract and one of them has been is the aggrieved party, they have the option to either choose to make the contract void, to rescind the contract, or to see it through, knowing that at the end of the contract they will receive some benefit, and in that instance they may choose to not make the contract void. So they do have the option of performing the contract, carrying out the contract, and seeing it through. So does voidable contract automatically render the contract invalid? This is the answer. The short answer is no, and this is seen in section 19 of the Contracts Act, where a contract is caused by coercion, fraud, or misrepresentation. The agreement is a contract voidable at the option of the party whose consent was so caused. So this is something that we will look at: free consent of parties. What is free consent? As defined in section 10 of the Contracts Act, all agreements are contracts if they are made by the free consent of parties. So parties must freely, not under any duress or undue influence or coercion, enter into the contract made by free consent of parties, competent to contract for lawful consideration. So there must be a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. So what do they mean by free consent? What constitutes free consent? It's when two persons are said to consent when they agree upon the same thing in the same sense. And this is when if there is a breach at any point during the enforcement of the contract, it will only be voidable and not void. So when is consent not free? Now, the Contracts Act sets out a few instances, and consent is said to be free when it's not caused by, as I've said, these instances: coercion, undue influence, fraud, and misrepresentation. While mistake is also stated here, but mistake in contract, as we have spoken about, will render it void. And yeah, so a contract caused by any of these factors are deemed to be absent of free consent and may be liable to a voidable contract. So let's first look at misrepresentation. Now, this is defined in section 18 of the Contracts Act, and it's where a representation is made by one party to another, which is not true, and therefore, and there are certain types of misrepresentations. For instance, let me run by you the three types: fraudulent misrep, negligent misrepresentation, and innocent misrepresentation. So let me give you an example. So if A enters into a SPA with B, whereby A states that the land in question is vacant and free of any encumbrances. However, after purchase of the land, B finds out that the land was being used by public authorities. So can this be considered as misrepresentation? Well, the short answer is yes. However, of course, when bringing an action premised on misrepresentation, parties would have to definitely choose whether the misrep was done fraudulently or negligently, or it was actually done innocently. So in a fraudulent misrepresentation, where a false representation has been made knowingly or without the belief in its truth or recklessly as to its truth, this is when it will be deemed as a fraudulent misrep. And if it's made fraudulently, then the representee is entitled to rescission and all damages under the contract. So where a party has successfully proven that, yes, I have been fraudulently misrepresented by party A, then I have every right to rescind the contract to basically restore my position back to how I was before the contract, and receive on top of that damages, damages that has been caused. And of course, this is something that that is quite widely seen in the courts. There are many cases premised on misrepresentation, fraudulent misrepresentation. There's an English case, Doyle against Obley. His Lordship Lord Denning in the UK held that in contract, the damages are limited to what may reasonably be supposed to have been in the contemplation of the parties. In fraud, they are not so limited. The defendant is bound to make reparation for all the actual damage directly flowing from the fraudulent inducement. So the defendant who has misrepresented has to make all reparation, not only restore, but also over and above that, will have to provide damages to the aggrieved party. So that is fraudulent misrep. Let's look at negligent misrepresentation. So this is when it was made negligently. The remedy lies in damages, in the thought of negligence, under the assumption of responsibility and reliance on the doctrine laid down in the locus classicus case of Hadley, Byrne, and Heller. So this is when a party who is actually who is a defendant, who is accused of misrepresenting and has done so, they have to prove that, okay, this was done. This was not done negligently. I had taken all steps to ensure that my representations were true, and the party bringing the claim has to show that that the party has actually misrepresented negligently, has knowingly misrepresented. Sorry, not knowingly, because that would be fraudulent. Has negligently misrepresented me in entering into this contract. So here, as the Hadley, Byrne, and Heller case has held, the representee must plead and prove a special relationship giving rise to a duty of care. So I'll have to first prove that yes, he had a duty of care and to me, and he had represented so and so. However, he had negligently done so because I'm actually misrepresented. I'm induced into this contract where I was promised one thing but was given something else. And this type of misrepresentation only arises in cases where there exists a special relationship between the representor and the representee. So the third type of misrep is innocent misrepresentation. And it's where the representor believes his assertion to be true and consequently has no intention of deceiving the representee. So here is where misrepresentation is innocently made, not knowing that I was representing to you something that was actually not true, that was actually false, and I induced you into coming into this contract when I had not known, innocently not known what the contract actually entails. So the leading case is Symptom Realty, where it held that it follows that the victim of an innocent misrep is not to be put in exactly the same position as if the representation had never been made, for that would result in an award of damages. All that is required is that the representee is returned to his position only as far as regards to the rights and obligations which have been created by the contract into which he was induced to enter. The interface of the remedies of rescission and restitution produces this result. So the representor, the person who has made the innocent misrepresentation, will not have to pay damages, but merely ensure that the aggrieved party is restored to his position as if the contract never happened. So this is to safeguard the interests of those that were misrepresented into entering a contract, and therefore the contract does not become void, it becomes voidable, because the aggrieved party can choose whether he wishes to perform the contract and continue and see through, or rescind the entire contract and go back to how it was, as if the contract never actually occurred. So there's a case of travel site against Atlas Corporation. In relation, the brief facts is it's in relation to a purchase of a property from a developer. The developer had misrepresented the purchaser on the size of the unit, as it was actually smaller than what was actually represented to the purchaser, and the purchaser succeeded in its claim under misrep. So this is a very basic and straightforward claim of misrepresentation, which is a false statement, something made to be untrue. So as you can see, it's something very straightforward. Now, fraudulent misrepresentation is very close to what I'll be speaking about next, which is fraud. And section 17 defines this as including any of the following acts committed by a party to a contract, or with his connivance, or by his agent with intent to deceive another party thereto, or his agent, or to induce him to enter into a contract. So this is very close to fraudulent misrepresentation. But here, what has to be shown is that the suggestion as to a fact of that which is not true by one who does not believe it to be true, the active concealment of a fact by one having knowledge or belief of the fact, a promise made without any intention of performing it, any other act fitted to deceive, and any such act or omission as the law specially declares to be fraudulent. So how does this differentiate from how is this different from fraudulent misrep? Fraudulent misrep is the inducement to enter into a contract. Here, there is no there is an active concealment of a fact or a promise made without any intention of performing it. So I can induce you, but I do not perform the contract at all, and that is fraud, not fraudulent misrepresentation. So there are several, there are many cases, authorities on this point. The leading one is a very old English authority back in the 19th century in Derry against Peake. It is established, so it stated that to establish fraudulent misrep, there must be proof of fraud. Fraud is proven when it is shown that there was false misrepresentation. And if fraud is proven, motive is immaterial. So all you have to prove fraud and deceit is very important to be proven. And what if the wrongdoer decided to be silent on it? Can this be considered as fraud? So many people question whether silence is important in cases like this. So the general rule is that silence does not constitute fraud. However, there would be certain situations where silence can amount to fraud, where they have a duty to speak. So, for instance, if you were not asked a question regarding a sale of an item, like if, for instance, you knew that the item was disfigured, but you did not mention anything, so that silence is not fraud. However, if someone asked you if the item was actually spoiled or disfigured in any way, but you remain silent, that having a duty to speak, but you have remained to but you did not, you remain silent, and that will be fraud. So once you have proven these elements, what happens next? When consent to an agreement is caused by coercion, fraud, or misrepresentation, the agreement in the contract is voidable. And in Sing Tong, as earlier mentioned, common law requirement that the misrepresentation must induce the contract. Now we think that we should say a word about this point. It has to do with the onus of proof. As a general rule, the burden is on the representative to show that the misrepresentation induced him to enter into a contract. So there must be an inducement to enter into a contract, and there must be a reliance by the representee. So I must have relied on your inducement to enter into a contract, and entering into the contract was a misrepresentation by you. So that are the key elements that are required to be proven before you can actually make a claim for the contract to be deemed voidable. Now, what are the remedies available where there is fraud and misrepresentation proven? When a contract is voidable, the innocent party has a choice to continue with the contract or to rescind it. As I've previously mentioned, the innocent party can choose to continue and insist on specific performance of the contract and be put in the same position as if the representation was true. So I can compel you to proceed with the contract and perform the contract and see it to the end and ensure that what you had represented to me actually comes true. So what are the consequences of rescission of a contract? So where a contract is rescinded, as the case of travel site has held, the parties must be restored to their original positions. So once a party chooses to rescind the contract and not perform it or see it through, they will be restored to their original positions. But it's also pertinent to remember that once the party elects to rescind the contract and not perform, that you can't make a U-turn on that, and there is no such thing as a partial rescission and partial performance. So it's either one. And moving on, to undue influence. So what is it and how does it happen? So given a scenario here, so A is B's banker and financial advisor. A knows that B places a lot of trust and confidence in A, and A is also involved in a few real estate development deals in town. B, who is not entirely interested, but A uses his power to convince B that it would be a good idea to invest in real estate. And what happens is it goes sour, and this is towards B's financial detriment, but increases the value of A's investment. So this is one instance where there's undue influence. I'm using my position and using your trust in me to increase my benefit or get a greater advantage, and at the same time it's detrimental to you. So this is provided for in section 16, undue influence. One of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. In the case of Malaysian French Bank, a person is deemed to be in a position to dominate the will of another where that person holds a real or apparent authority over the other. So as seen in the previous example, A was in a position of dominance, and it used its position and the trust of B to enter into those real estate deals. So this is how undue influence happens. And when there is an undue influence and it's proven, the contract can be voidable at the option of the party entering into the contract. So in the previous example, B would then have the option of making the contract voidable. Now, there are two types of undue influence. This is seen in the House of Lords decision of Barclays Bank against O'Brien. So there is actual undue influence and presumed undue influence. Now, the difference is for actual undue influence, the claimant has to prove that the wrongdoer exerted undue influence on the complainant to enter into the particular transaction. However, for presumed undue influence, the claimant only has to show that there exists a relationship of trust and confidence between the complainant and the wrongdoer in the nature that it would be fair to say that the wrongdoer abused that relationship. So, for instance, if you can't prove that the wrongdoer actually exerted undue influence, actually made you believe that taking our previous example, made you believe that that investing in my real estate development would bring you benefit, so that would fall under presumed undue influence rather than actual undue influence. Now, the only difference between these two is the burden of proof. However, the result and the consequences of actual or presumed undue influence is the same. The contract is still voidable at the option of the aggrieved party. And the remedies available here is one of restitution. So the voidable contract can be set aside, absolutely. And in doing so, the court will restore the parties to the position that they were in before the contract had taken place. So as you can see, this is also very much in line with the breaches of fraudulent misrep and fraud, and it also causes the contract or agreement to be voidable. So here you can see the difference between the two. A void contract is valid when it's made, but subsequently becomes unenforceable on certain grounds. An example of it, contracts caused by mistakes. And for a voidable contract is voidable at the option of the aggrieved party, and hence remains valid until such rescission. So in a void contract, as soon as the contract is unenforceable, it will not be valid any longer. However, in a voidable contract where it's seen to be unenforceable, the aggrieved party can still choose to carry on until they decide to rescind. So as I've run through with you, let's conclude today's presentation. So a summary, as you can see, void and voidable contracts are two very distinct areas of the law. Its effect on a contract are very much different from one another. In one case, the contract is halted right away, while in another case, there's a possibility that the contract can still be performed. So a void contract will render the entire contract invalid, whereas a voidable contract is only invalid when the aggrieved party decides to rescind. And a void contract is vitiated by conditions, among others, in the contract against public policy, restraint of trade, and mistake. And as you can see, for avoidable contracts, as I've run through with you, where there's a lack of free consent, such as misrepresentation, fraud, and undue influence. So I hope that that was clear. Now, if you have any questions, I'll be happy to address them. So first question is by Victor Pang. What happens if the representation was true at the time of making, but subsequently turned out to be false due to change of circumstances? So, well, this is, of course, you have to look at it on a case-to-case basis. As I've run through the various misrepresentations earlier. So if it's during the performance of the contract, it happens to be false, the representor, that means the person who's making the representation, would have probably not knowingly done so. So this would fall under innocent misrepresentation, and therefore the possibility is that the contract will just be voidable at the option of the aggrieved party. But because it's an innocent misrepresentation, the representor won't be liable for damages since it was not foreseen. Next question is by Alfred Chong. What is the difference between fraud and fraudulent misrepresentation? So as I've run through earlier, fraud, there are different elements and criteria that you have to prove. Fraud, you do not have to prove that there was an inducement to enter into a contract, and there was a reliance by me, and there was an actual representation made by you. So the elements in fraud is different from the elements in a fraudulent misrepresentation. Misrepresentation is very important that you prove that you were represented something and you were induced to enter into the contract based on that representation, and you had and based on that inducement, you had relied on that inducement, entered into the contract, and subsequently suffered damages because the representation turned out to be untrue or false. Do we have any further questions? If there are no further questions, I'd like to thank you very much for joining me this evening. If you do have any further questions, you can always email me. It's on the screen. Other than that, thank you and good night.